Okay, so that's the lecture. So today, inshallah, we are going to complete everything on damages, and this is one of the last, okay, the remaining subtopic under the big topic of damages. So for today, we are going to look at damages in cases of damage to property. So all this while in our previous lectures, okay, we spent quite a number of lectures to discuss about damages for personal injury and then damages for death or fatal accident, and we are done with it. So for today, we are going to focus on damages in cases of damage to property. Meaning that here it's possible for the plaintiff, okay, for the claimant to suffer damage, or injury to personal injury, as well as the property damage. I mean the property is also damaged. For example, the damage to the car, the damage to the vehicle, the damage to the building, for example, to the property, whatever kinds of property here. So what's the rule governing damages here? Okay, there are two circumstances, okay, when we talk about damages in case of damage to property. The first one, okay, what happened to the property? It is totally destroyed, or we call it total destruction. It's not possible to fix it. It's not possible to repair it. Okay, so it falls under the first category, which is total destruction, or maybe if it involves accident or insurance, can we have the term total loss. Mean that here it's not possible to repair or to to fix it. And another situation, another circumstance here, mere damage. Mean that here it's possible to repair, but of course whatever that you repair or fix, it won't be the same again, but still it can it is still possible to be used later. Okay, so we focus on the first one. Okay, we want to know, okay, what is the rule or principle governing the circumstance of total destruction? Okay, what the plaintiff can recover. So there are two things actually that plaintiff can recover. Okay, the first one, the value of the property when at the time of destruction. Mean that here whatever amount of the, for example, vehicle, okay, total loss. So what's the amount of the vehicle, what's the amount of the car at the time of the accident? Okay, not the amount the new car whatsoever. Okay, the market value of the car, okay, at the time of accident, at the time of destruction, because it's no longer usable after that. You cannot use the car after that. Okay, it's total loss. So first can recover the value. And another thing here is also possible to recover consequential economic loss. Whatever losses, okay, in consequence of the damaged total loss of the car. Meaning that here is it may or it may not be relevant. It depends, okay, on the situation. So what's the meaning of consequential economic loss here? It means any loss, okay, as a consequence of the destruction of property. And if it involves business, it also covers loss of profit, okay, for the business. It depends very much on the situation. So we have a look at the case law. Okay, this is the case. This is the landmark case for damage to property. The case is Lee Bosch Dredger and S.S. Edison, 1933. Very, very old case, actually, classic case here. It involves, it is pertaining to destruction of a dredger. Okay, if you are not familiar with the word dredger, I'm also not familiar, so I Google the meaning. Dredger refers to certain vessel, okay, which is used to collect sand, okay, from the seabed, basically, or whatever material on the seabed, maybe to do the cleaning or to make it deeper. Okay, so here what happened was that there was negligence on the part of the defendant. So the defendant admitted liability, okay, for negligently sinking the Libosh, the dredger. So now what's the issue? Okay, what's the issue we want to focus on? The issue is pertaining to how the damages should be calculated, how to assess the damages. And the court held that complainant, the plaintiff, could not claim for their additional higher contract expenses because this was not foreseeable by the defendants. So the only recoverable damages would be the market price of the replacement for the Lee Bosch dredger. Because actually for this case, the claimant has problem to buy a new one, okay, limited fund to buy a new one. So they decided to hire, okay, hire rather than buy. So can they can they claim for the cost of hire? But because they know you can only claim for the market price of the replacement, the value of the dredger, basically. So additional hire here is like a replacement of the you are supposed to buy a new one, but you choose to higher and you bear higher cost, okay, more cost, additional cost. So that one the court didn't allow. Okay, you can the claim is only limited to the market price. Usually it is more expensive if you hire. It's like your car is damaged, okay, and then you hire a new car. I think hiring or rental car rental or even dredger rental here, it costs more because it is counted based on daily usually or even monthly. It will cost more compared to you buy a new one, especially it is for a long term. That's why the court only allow, okay, the amount of the market price of the replacement for the dredger. So here, in this case, the court awarded first, okay, the market price of the new dredger and also the cost of transport of the new dredger because it's not easy to transport such a big or huge vehicle or transport lah. Okay, I mean, it needs, the cost is more. I mean, it requires lots of expenses, okay, to transport the new one here. And then the court also allow compensation, okay, for the plaintiff loss of carrying out the contract with the third party. So this is consequential, okay? Consequential to the losses of the dredger. So you can claim for this compensation, okay? Because claimant is supposed to carry out, okay, is supposed to do the contract with another third party. So because of the loss of the dredger, so they cannot proceed with this contract. So yes, you can claim for this as well. So these are all under the first category. Okay, we are discussing about the total destruction. So the dredger was actually destroyed lah, basically. Okay, sinking. Okay, the second one. Okay, what if it is a case of mere damage? It's still possible to repair. Okay, so basically, there are two options available to the plaintiff or defendant. First, okay, you can repair and continue using it. Okay, repair and then use it as usual. All right, but we want to know what's the damages allowed. Okay, the quantum, okay, the amount. And another option, you don't want to repair your car, or you repair but you don't want to use it anymore. You can sell the damaged item. Okay, again, there's a way, okay, to calculate the damages, because if it is total destruction, you cannot repair, and of course you cannot sell it. All right, so this is the option available for cases or for situations of mere damage only, damage which is still possible to be fixed or can be repairable. Okay, here, if the plaintiff selects or chooses to retain the damaged property and intends to repair, so he can recover the cost of repair. So whatever cost, for example, 10K to repair, then can claim, okay, the cost of repair from the defendant who caused the negligence. But let's say you don't want to use it anymore, okay, you want to sell it, okay, of course it will affect the price because it is a damaged property, okay, it's not like the property which is not damaged. So if plaintiff intends to sell the damaged property, so what plaintiff can recover in that particular situation? First, okay, plaintiff can actually recover the diminution or reduction in value of the property. Obviously, okay, the damaged property will be lower in value. Okay, if you want to sell, it is very cheap price lah usually. For example, if Proton Azora, just whatever example that come across to my mind. So Proton Azora second hand is 30K, for example, but it was involved in the accident. Okay, after the damage in the accident, so the price drops even more. So plaintiff can only sell for 10K, for example. Okay, so now the difference of the price, okay, plaintiff now can claim for 20K, the reduction in value, because if it's not damaged, actually it is supposed to be sold at 30K rather than 10K. So the 20K difference here, reduction in value, can claim from the defendant. Okay, this is for the situation or cases of mere damage. This is the example of the case. Okay? Just now we have demonstrated. So this is local case. This is the decision by federal court, I think. You see the federal court? Yeah, federal court. Right. So very high weightage. The case name is Liu Choi Hung and Shah, Alam Properties, 1997. This is a bill case, obviously. So appellant's home, okay, the house was damaged due to what? Due to nuisance and negligence of respondent. And then what happened to the house? The act of the defendant, it caused flooding and severe water clogging. And then in that particular situation, okay, appellant, the house owner, chose to repair the damage. Okay, there's one latecomer. Okay, I don't want to admit if you are late. Nurin, you are late, okay? So try not to be late next time. We were discussing about this case. Okay, it caused flood and severe water clogging, and the house owner appellant chose to repair the damage. So we want to know, okay, what's the amount of the damages awarded by the court? This is federal court decision. So federal court said that appellant, should be entitled to first the cost of repair, whatever amount needed, spend to repair the house, actually a big amount, and then as well as diminution, in the value of the property, because usually whenever the property is damaged, or maybe certain area, in which it is prone to or always happen flood whatsoever, there's a stigma, by the society attached to it. So of course the value will be lower compared to other property of the same design, for example, same size, but then because of the location, if it is the location which always happen flash flood, for example, of course the value or the price will be lower. So we call it by or the court actually explained it is a stigma attached to such property within that location. So we are done basically with damage to property. It's a straightforward discussion. The rule is also simple, and we only limit our discussion to 2 cases. You can have more actually. If you refer to textbook, I think you have more cases. But this is the compulsory case that you need to know, because this is by federal court, and Libosh is the landmark case for common law. So both cases you have to know if you are discussing damage to property. If you are resolving a problem on damages, damage to property may or may not be relevant. It depends lah whether the fact stated the parties or the applicant or the plaintiff vehicle is damaged, for example. Then you have to explain lah the rule with regards to damage to property. But if there's no facts about it or no indication about it, then you can just skip. No need to discuss about damage to property. And the last part of our topic is mitigation. Mitigation might be relevant. Most of the time it is relevant for to resolve a problem, because mitigation is relevant, or the duty, legal obligation imposed on the part of the plaintiff, the one who wants to make the claim. So there's certain legal duty imposed on him as well. Okay, so what's the rule here? Defendant is generally liable for the damage sustained. No issue about it. We know about it. But on the other hand, plaintiff also has a corresponding duty to minimize his loss. On the part of the plaintiff, he has to show his best effort to minimize the loss, not to maximize the loss, because maybe he was anticipating, oh, it's okay, I can claim everything from defendant. No, it doesn't work that way. The legal duty on the plaintiff must try his best to minimize the loss. Not to purposely, intentionally increase the loss lah, basically, with the hope that, oh, you can claim everything from the defendant. So when the case is heard in the court, when the case goes for trial, plaintiff should show, or must show actually to the court, that he has tried his best to deal with the injury and his life after the injury. We are talking about personal injury now. We are not talking about the death or whatsoever here. We are talking about personal injury. Okay, so what happens if the plaintiff doesn't do mitigation? I mean, the plaintiff is supposed to do to mitigate the loss, but he failed to do it. He omits to do it. What's the effects? So failure of the plaintiff to take protective steps after suffering an injury or losses can reduce the amount of the plaintiff recovery later. Cannot claim for the full amount lah, right? It's like when we discuss about liability, liability against plaintiff, liability against defendant. If it is not 100% liability on the defendant, so certain reduction based on the fault. But here it will, I mean, this is another principle, but it will actually decrease the amount of the quantum or the claim later, if there is any failure of mitigation. Okay, let's have a look at the case here so that it will be clearer. Yung Liok Ki Corporation, Sdn Bhd, and Chin Tong Tai. Okay, make sure you spell it correctly. Decision by federal court. So it's very, it's applicable to all courts, lower courts here. So this is appeal case. Respondent was awarded damages. Okay, for what? For injuries sustained by him. What happened? In the course of loading logs onto a conveyor belt. Okay, there's an accident. And there's actually, yes, the court found that the defendant, the employer, was liable. Okay, so we don't dispute this fact. But this is the argument, okay, by the applicant. By the appellant. Okay, APPL is appellant. So appellant argued that the learned judge failed to consider. That's why he filed this appeal. Okay, failed to consider the duty placed upon the respondent, the employee, to mitigate the damage. Okay, not during the accident. Okay, but after it. Okay, to mitigate the damage when he left the hospital against medical advice. Yes, he suffered injury due to negligence of the employer, but he need to undergo all the treatment. Cannot simply discharge himself from the hospital against the doctor's advice, because he cannot claim later whatever injury suffered to him. So the award for loss of future earning, okay, the court reduce it. That's the effect. Reduced from 42,000, it becomes 21,000. Half, 50%. So mean that here, mitigation, duty to mitigate is such a, it's very important. Okay, it is imposed on the part of the plaintiff or claimant or the victim who suffered the injury. And this is what Abdul Hamid, federal court judge said. This is the actual wording, judgment. He said that thus the onus is the burden, okay, falls upon the respondent, okay, to do what? To take all reasonable steps to mitigate the amount of damage. You are not supposed to try to claim the maximum and failure on your part to mitigate. And it is evident, it is very clear, okay, that the respondent acted unreasonably when he left the hospital against medical advice. So everybody will say, oh, you shouldn't actually leave the hospital. Okay, you have to undergo all the treatment. And the court said, if he had remained in the hospital to continue with the treatment, okay, even if the leg was amputated later, but you have to undergo the therapy whatsoever, the full treatment, then the court said he will be able to lead a normal, healthy life. At least you have the leg which is replaced with the artificial, okay, that's the word, artificial leg, or we call it prosthesis, kan, okay. Mean that here you can still have a healthy life lah, okay. You can still continue with your usual life, but now you discharge yourself against again the advice of the hospital or the doctor, then the injury gets worse actually later, okay. The wound, okay, becomes bad, okay, after that. Okay, we are done with mitigation. So we only discuss one case. Actually, you have more, but this is judgment by federal court. So it shows to us application of mitigation. Okay, and this is only for your knowledge actually. Okay, remember when we discuss Civil Law Act, especially section 28A and also section 7 and 8, there are some amendments which has been done, okay, to certain provision. And actually, it's quite recent amendment. Okay, it's quite recent. The amendment which was done, it took effect from 1st September 2019 onwards. So 1 year plus lah. Okay, not even 2 years. So it's still recent. It's still new. Okay, so what do you need to know? You have to know the latest one. Okay, but I just want to highlight what was the position before, the previous position of law. So previously, okay, where the death of person was caused by a wrongful act, compensation could only be made, so a certain limitation, okay, could only be made to the wife, the wife or husband, the spouse, and also parent and child, okay, wherever relevant. And after the amendments, okay, amendments in year 2019 here, amendments now include any person with disabilities, disabled person, under the care of the deceased. This is about section 7. Okay, mean that here before this, there's no such thing. And then here. Alright, so what's the meaning of the word person with disabilities here? Basically, we need to cross-refer to Persons with Disabilities Act 208. Okay, that's the year, and it is interpreted as it includes those who have long-term physical, mental, intellectual, sensory impairments. Okay, so it's such a broad interpretation of the word, because sometimes we have mentally disabled rather than physically disabled. That's why if you read social media kan, if you are a normal person and uh, you park your car in the space provided for disabled kan, so mean that here you are mentally disabled. Right, actually that one is meant for physical kan, physical disabled. There must be proper sticker whatsoever. Okay, which interrupt, so you can read the full interpretation here. And then this is some other the amendment. Okay, what happened after the amendment? In respect of section 28A, okay, before the amendment, the age was 55. Okay, those days, okay, especially civil servant, then the official retirement age is 55. But later, okay, we have Pensions Amendment Act 2011 and minimum retirement age 2012. Then it is increased. So government servant applicable to private as well, but private they have option lah. Okay, so government servant usually they will work until 60. That's the maximum. Okay, but then you can opt to retire early. Okay, alright, but you have to wait lah until the 60, then you get the pension. But like I said, for UIA, we don't have pension. So for UIA, when I joined UIA last time, IIUM, okay, I joined in year 204. I mean, they keep on changing the law actually. When I joined, I have to until 58. So, and then later they increased up to 60, but I didn't sign the form to increase until 60. So my official retirement age, even in the system, is up to 58. So right now I'm 45, so 58. Ada 13 years more get to work, basically. Okay. So accordingly, it affects the computation, okay, the calculation of multiplier lah. Okay, before the amendment, it is 59 minus the age of accident, the age at the time of accident divided by 2. But when it was increased, then 60 lah, 60 minus the age of accident or the age of the death, okay, and then minus by 2. And then before the amendment, actually there was another requirement, okay, plaintiff must prove he was in good health prior to accident. Okay, but now there's, I mean, no longer need lah. Okay, it's no longer a requirement. And then also amendment to the bereavement. Okay, the amount of bereavement. Previously, before year 2019, it was 10,000, okay, lump sum. But now it is increased to 30,000. I think very good actually, bereavement. Okay, the state of sorrow. And the last one, okay, prior to the amendment, only the spouse of the deceased and parents of the deceased who was a minor. Mean that here, bereavement is only limited to certain people. Okay, meaning that here only spouse can claim and only parents can claim if the deceased is a minor. Okay, so if the deceased, if the child is no longer a minor, cannot claim. Alright, but now the amendment is that the child of the deceased person is also now entitled to claim for the damages for bereavement if the parents died, basically. So they broaden, okay, they make it they include some other person to claim for this bereavement. Okay, we are done. I stop share. Okay, so we got